As you know, the United States Supreme Court granted cert and vacated the lower court win in favor of the Second Amendment just yesterday in the Lara versus Pennsylvania case, dealing with the Second Amendment question of whether or not 18, 19, and 20-year-old young adults have the same right to keep and bear arms as the rest of us. This is a very important case for us to win because of the ripple effect on all of our Second Amendment rights. Because as you know, it's not just about who wins the case when we're talking about the Supreme Court and court decisions, it's also how we win. We want to make sure the methodology and the interpretive approach that courts use are favorable to us. Otherwise, it will come back and bite us in the butt down the road. So I want to talk a little bit more about some of the inside fights that I think are taking place within the U.S. Supreme Court among the justices, dealing with some of the issues involving the 18, 19, and 20-year-old cases and what that means for us. I don't think it's terrible, but you need to know this if you want to be the smartest person in the room. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Israel Disarmed, What the 10/7 Attacks on Israel Teach Americans About the Right to Bear Arms. Check it out on Amazon if you don't have a copy. And if you have a copy, feel free to leave a review. Let me know what you think of the book. All right, folks. So just yesterday in the Lara versus Pennsylvania case, which dealt with a quirky issue, in a sense, of what happens if the state of Pennsylvania, like through their governor, declares an emergency, for example, COVID or a natural disaster. Because under Pennsylvania law, believe it or not, if a state declares an emergency, it means that 18, 19, and 20-year-olds cannot carry guns outside the home, unlike other Americans in Pennsylvania. The plaintiffs sued the Commonwealth of Pennsylvania, arguing that this provision does get implemented sometimes, meaning there is sometimes a state of emergency, and when that happens, 18, 19, and 20-year-olds are denied their right to keep and bear arms because they're not allowed to carry guns in public. The right to keep means to possess, and the right to bear means the right to carry in public for self-defense, i.e. the right of the people to keep and to bear arms shall not be infringed. So this case ultimately went all the way up to the United States Court of Appeals, a federal appellate court for the Third Circuit, overseeing Delaware, Pennsylvania, and New Jersey. And the Third Circuit said that indeed this violated the Second Amendment, because if you look at the text of the Second Amendment, the right of the people to keep and bear arms includes 18, 19, and 20-year-olds, obviously, for a whole host of reasons, not least of which was in the year of our Lord, 1792, the federal Congress enacted the Militia Act of 1792 at the time of the founding and found that 18, 19, and 20-year-olds were part of the militia that had an obligation to bring their own firearms, to bring their own ammunition, to bring their own pouches and cartridges and so on with them to militia musters. So if 18, 19, and 20-year-olds had an obligation to bring their own firearms and weaponry with them to militia musters, it seems kind of obvious that at the time of the founding, people thought 18, 19, and 20-year-olds had the right to keep and bear arms, to the point where they actually had an obligation to show for militia musters with their own stuff. Beyond that, even if you look at contemporary times, which you don't need to do, but let's just for the sake of argument, look at them. We know that under, I believe, the 26th Amendment, 18, 19, and 20-year-old young adults in America have the right to vote. So how is it they have the right to vote and they have all these other rights, the right to change their sex, the right to have an abortion, the right to enter into contracts, the right to get married, the right to be drafted, the obligation to be drafted, right? The right to join the military, and so on and so on. How would they not also have the right to keep and bear arms, just like they have the right to free speech and the right to pick a religion and to worship the God of their choice? So anyway, the Third Circuit said, indeed, this was a violation of the Second Amendment for the state of Pennsylvania to do this, and that was the decision. The state of Pennsylvania sought cert, which just means they asked permission of the U.S. Supreme Court. They asked the Supreme Court to hear this case, and the Supreme Court granted cert. Then they vacated the lower court decision and remanded it. Why? Because, here's the key, we talked about it yesterday, because the Lara decision by the Third Circuit was decided before the Supreme Court issued the Rahimi decision. Now, you could argue that there's no connection, and I don't think there really is much of a connection, but the truth is the U.S. Supreme Court, when they apply their rule of when they GVR a case, which means you grant cert, vacate the lower court decision, and remand it back for further consideration in light of something. Basically, if there's any conceivable way that a Supreme Court decision could impact that case, it's pretty routine for the Supreme Court to send it back. Now, with all that said, I'm bringing you up to speed to get into the point of today's video, which is why I think the Supreme Court may have decided to kick back the Lara case. And I think there's three possible answers here. I think the first answer is unlikely to be the answer, but I'm going to put it on the table. The first answer is that the Supreme Court has no interest in enforcing the right to keep and bear arms, and they don't care about the Second Amendment anymore, and they don't want to hear any more Second Amendment cases. I don't think that's true. I think, for example, this term alone, we've already seen that they took the Vanderstock case dealing with the ATF overreach, and they've already taken the case dealing with Mexico, the government of Mexico's attempt to destroy the American gun industry. So the Supreme Court has already taken two Second Amendment related cases already this term, and if they do what I'm hoping they will do in December/January, and that is to grant cert and agree to hear the Bianchi/Snope case, which is the most important case in the Second Amendment that we haven't resolved in our favor at the Supreme Court level, even though we technically have with Heller. We need to clarify this because lower courts are misbehaving. And that, of course, is this AR-15 ban issue, whether or not states can ban semi-automatic rifles. And I don't think there's any way they possibly can, but we need the Supreme Court to take this case and clear this up because lower courts are misbehaving. They need to be spanked. Now, we're not going to know if they're going to take that case of Snope until, like I said, probably early January, because it's going to be conferenced in mid-December. But I think there's strong evidence the Supreme Court's looking carefully at that. And if they take that case, I kind of understand why the Supreme Court wants to clear the docks of the other Second Amendment-related cases, because that Bianchi case/Snope case will be a very, very big case and a big win, I predict, for the Second Amendment community if they take the case in June of 2025. So the first answer is that they don't want, the first possible explanation why they denied, basically refused to hear formally the Lara case is that the court's not interested in Second Amendment cases. And first of all, I don't think that's the case for the reasons I just articulated. And again, the second reason may be that they are looking down the chessboard and they're going to hear that big Bianchi-Snope case, and they're looking for a way to kind of jettison these other cases along the way and buy a little bit of time because they know they got a big Second Amendment case coming up, and they're going to take that, and that's what they plan to do. That's a possibility. Number two. The third possibility, and there's really two other possibilities here. Now we're going to get a little geeky. I'm warning you now. The third possibility deals with this issue that I've written about in the Harvard Journal of Law and Public Policy about which is the proper time period for looking for historical analog laws to use to interpret if there's a longstanding tradition of restriction on a Second Amendment right in some way. Do you look at the year of our Lord 1791 when the Second Amendment and the rest of the Bill of Rights was adopted? Or do you look at the year of our Lord 1868, which is a few years after the end of the American Civil War, when the 14th Amendment was adopted? Now, the reason why I think there could be some tension here, and this is the key part to understand, and this is the geeky part. There is a little bit of tension between Justice Thomas and the rest of the Supreme Court over what's known as the Doctrine of Incorporation. Now, what is the Doctrine of Incorporation? The Doctrine of Incorporation says that the original Bill of Rights, which was adopted in the 18th century, 1791, originally applied against and restricted only the behavior and conduct, powers, of the federal government. And it was only in the year of our Lord 1868, after the Civil War, where the Bill of Rights, adopted in 1791 originally and only applied against the federal government, it was only in 1868 when those Bill of Rights were incorporated against states and localities. So the question is, intellectually and scholarship-wise, legally, if you're trying to interpret the Bill of Rights, do you look at 1791, see what people understood it to mean then, or do you look at it in 1868, when it was incorporated and applied against the states? Now, Clarence Thomas has a little bit of idiosyncratic view on this. It's not crazy. There's an argument that he's theoretically correct. But in the real world, in the practical world, it's probably not going to get very far. And that is this. The process whereby the Bill of Rights is incorporated against the states and localities is through what's known as the 14th Amendment's substantive due process clause. Now, Clarence Thomas thinks that's not correct, that the due process clause of the 14th Amendment is not the proper means by which the original Bill of Rights applies to the states and localities. Instead, Justice Thomas believes that the proper way of doing this is through what's known as the 14th Amendment's privileges and immunities clause. Now, the argument goes among some scholars, I don't agree with this, but there's some scholars that say that if the proper approach for incorporating the Bill of Rights against the states is the privileges and immunities clause, which Clarence Thomas says indicated in the past, that's what he believes, then the proper time period is to look at 1868 and try to understand what did people think the privileges and immunities clause meant then when you're going to apply, for example, the Bill of Rights, including the Second Amendment against the states. Now, we've talked about why, in my view, as a general matter, looking to the 19th century is bad for the Second Amendment movement. Why? Because if you look at the late 19th century, there is a lot more anti-gun gun control laws because the South, after the Civil War, and some northern cities as well, were looking to disarm the recently freed African-American slaves, and as a result, they would pass these neutral-sounding gun control laws, but everyone understood, the local sheriff understood, the police departments, everyone understood that the reality was even though the law was a gun control law about prohibiting concealed carry or whatever it was, everyone understood with a wink and a nod in those jurisdictions that this was only going to be enforced against African-Americans. But again, you still have on the books in the late 19th century these gun control laws that the anti-gunners in modern-day America can point to and say, look, the late 19th century, there's all these gun control laws dealing with like guns in parks. You can't bring guns into parks, let's say, or you can't carry a gun, or this or that. See? Therefore, there's a long-standing tradition going back to 1868 that allows us to justify the modern-day gun control law. Now, that argument becomes much harder if you do what I want to do and what I've argued is the proper way of doing it and what the Supreme Court has historically done. You look to the year of our Lord, 1791, at the time of the founding, because as a practical matter, just as a practical matter, there were a lot more gun control laws in 1791 than there were in 1868. So you see the tension? So Clarence Thomas, Justice Thomas, believes, as a matter of incorporation theory, that the proper way of doing it is the privileges and immunities clause of the 14th Amendment and not the due process clause. Now, the reason why this is important is in modern history, the way it's been always has worked in the U.S. Supreme Court is they use the substantive due process clause, which, yes, is an oxymoron, substance and procedure, but still that's what it's called, the substantive due process clause. They use that to incorporate all these Bill of Rights against the states, and that's what has always been done as a practical matter. So Justice Thomas, though, would like to, I think, undo that and do it differently, but I don't think there's 5 votes to get into that. Now, the reason why this all relates to whether or not the Supreme Court took the Lara case or will take, let's say, the Reese case, which is what I believe they're going to take the Reese case out of the Fifth Circuit when we win in the Fifth Circuit. That's my prediction, because the Fifth Circuit Reese case is against a federal statute, and the Reese case, and you'll see why this is so important to my discussion of 1791 versus 1868. In the Reese case, they're going to, I believe the panel, the 3-judge federal court panel in the Fifth Circuit, is going to hold that the federal law, here what I just said, the federal government's law and restriction, this is that 18, 19, and 20-year-olds cannot buy handguns from an FFL. They're going to hold that's unconstitutional. That's a federal law. And then they're going to seek cert on that. The DOJ will seek cert, and that I think will be granted cert. Now, here's why I think this is important. Okay, this is where you become super geeky and a Second Amendment scholar guru if you understand these fine distinctions and how it all works together. Because the Reese case deals with a federal law and the Second Amendment, you do not, listen carefully, you do not, and the Supreme Court does not have to, do what? They don't have to consider or get involved with the 14th Amendment's fight, the fight over the 14th Amendment's incorporation doctrine issue. They don't need to embrace and get into a debate between Clarence Thomas dealing with privileges and immunities clause of the 14th Amendment and the long-standing precedent involving the substantive due process clause of the 14th Amendment. You avoid all that in the Reese case, but you had to deal with it in the Lara case. And why is that? Because the Reese case deals with the federal law, which means you only have to go back to 1791 and say, well, the Second Amendment applied to the federal government in 1791, so just look at 1791. But in the Lara case, where they just GVR'd it, you'd have to look at the 14th Amendment, and arguably would have to look at laws from the time of the adoption of the 14th Amendment if you embrace certain theories, such as the Privileges and Immunities Clause, as the means by which you incorporate. To avoid this fight, if the Supreme Court takes the Reese case, but not the Lara case, which seems to be where they're trending, that's how I see it. They dodged that question, meaning the Supreme Court dodged the question between the Clarence Thomas view of incorporation using the Privileges and Immunities Clause against longstanding precedent and the rest of the court dealing with incorporation of the Second Amendment through the 14th Amendment as applied to the states using the Substantive Due Process Clause. And by taking the Reese case, granting cert in the Reese case, but not in the Lara case, they resolve that conflict by simply taking a case dealing with federal law where you don't have to get in to discuss the 14th Amendment at all. You see, that is I think this may actually be a consideration going on inside the justices' chambers about why they might pick the Reese case over the Lara case. It's this technical fight, intramural fight, but very important fight between the Thomas view of the 14th Amendment and the sort of standard precedential view of incorporation under the 14th Amendment. Now, the last point I want to make real quick is there is another case that is coming up that this may be the final. This is my fourth and final explanation of why they may have done what they did with Lara yesterday, and that is the Worth case. You may recall the Worth case coming out of Minnesota also deals with 18 and 19 and 20-year-olds. This is a case that does deal with a state law, so the 14th Amendment would come into play there. But the difference with the Worth case versus the Lara case is the Lara case was decided before the Rahimi case was decided in June of 2022. The Worth case was decided after the Rahimi case. So to the extent the Supreme Court says, look, we're just going to deny we're going to GVR, I should say, every case that was argued and decided before Rahimi, and we'll look at every case decided after Rahimi. That would be another way to distinguish the Lara case from the Worth case. So that could be the other possible reason that they just said, let's do the Worth case later this year instead of Lara, because Worth was argued and decided after Rahimi. Lara was not. So let's just take Worth so we don't have to worry about it because it's the same issues presented, dealing with 18, 19, and 20-year-olds as being part of the people, as in the right of the people to keep and bear arms. Again, I want you to understand these different permutations because this is not the sort of thing that is readily understood by many people or most people in the Second Amendment community, because why would anybody devote their life to understanding all this stuff? It's very complicated and it's very inside baseball, and I want to bring you the summary. But I do think that there's some tension there among the Supreme Court justices over this incorporation doctrine, and that may play a role in which cases are granted cert, in which cases are not granted cert. And again, it's very important for our community that 1791 be adopted because the anti-gunners really want to use the late 19th century gun control laws to show a long-standing tradition of firearms regulation to justify modern-day gun control laws, and we don't want that. All right, folks, so there you have it. Hope you learned something here today. Make sure you follow me on X at 4Boxes Diner. We have almost closing on 19,000 followers over on X. We should always support Elon Musk. He's done a great job for free speech in America and the First Amendment, so support him. That's my view. And again, make sure you follow me, like this video, and subscribe to this, and we will talk to you again very soon, I hope, here at the 4Boxes Diner.
Orders up. Table 2A.